Hey, good afternoon, everybody. Welcome. Special Sunday edition, the Trump's been indicted by the feds edition of Law and Legitimacy. Today's Sunday. I think it's June 11th. It's 2022. And good afternoon, Luttrell. You must have had your machine time to set this at 2 o'clock. I don't even know if you're there, but you got in first today, and obviously we're always happy to see you. So, the week ended, Mike, with big news. Donald Trump indicted by the feds. And we were just doing what everybody else was doing, playing catch up as quick as we could. I've now had a chance to read through the indictment. I don't know if you have, but it's interesting reading.
Yeah, I have 38 counts included in this indictment, which is a bit more than the 7 that we reported on Friday, based on the information available.
Well, we left the 3 off, the 37-7. I mean, look, I'm looking. There's a sheet that at the end that is what's called the certificate of a trial attorney. This is basically an internal document that sets the schedule and gives the court some information on what to do with the case. But I'm seeing a note from Luttrell. Oh, I'm here. 5 minutes early is on time. Well, I get that. I'm in the same boat, Luttrell. So anyhow, what we learned from this is, there are obviously 37 counts. The trial is estimated to be from 21 to 60 days. The lawyer is expected to alert the court, it's trial going to be 0 to 5, 6 to 10, 11 to 20, 21 to 60, 61 and over. They say 21 days for the trial to take place. So that would be 4 5-day weeks or 5 4-day weeks. I got a hunch it's going to take a little bit longer than that. When you look at the counts themselves, as to Donald Trump, he's got 31 counts of willful retention of national defense information. Each count carries a maximum of 10 years, and the maximum fine per count is $250,000. You're thinking, wait, he could do 310 years? I don't think so. There are grouping rules, but
none of us would know if he were still around.
Some of the press will say that. I mean, funny story. A client of mine was once, the government sought the death penalty. He didn't get it, but it got multiple life terms. So the judge had to be in her bonnet and was taking great relish in sentencing into consecutive life terms. So we started laughing, and she took exception to that and said, what are you laughing about? And I said, Judge, you do realize that given the sentence you're imposing here, any sentence, anytime he dies, you've got to revive him so that he can begin to serve the next sentence. Otherwise, it's an illegal sentence. She didn't see the humor in that. Count 32, conspiracy to obstruct justice. That carries a maximum of 20 years. Count 33, withholding a document that it's necessary as part of an official proceeding. That's another 20 years. Corruptly concealing a document. That's another 20 years. 35, count 35, concealing another document. There's 20. A scheme to conceal is 5. So, you add it all up. He's got a lot of time coming. His buddy, who I don't know a lot about, Waltine Nato, or Nata, I don't know if I'm pronouncing it correctly, Nauta. He's also facing 38 counts, and it's pretty much the same thing. It's a 2-defendant, multi-count indictment in Miami. And Miami is rumored to be a rocket docket jurisdiction. Jack Smith, the special prosecutor appointed to do all things pertaining to Trump, gave a press conference when the indictment was released late last week, promising a speedy trial. So it would not surprise me to see Trump on trial relatively soon. As to the indictment itself, indictments are scary documents. There are nominal indictments that don't lay out a lot of facts, and then there are more lengthy indictments that lay out a lot of facts. They laid out a lot of facts here, and what they are trying to do is to persuade the public that Trump broke the law, and to mute criticism that this was an act of selective prosecution that was unwarranted by the facts.
Hey, Mike, do you think that they would accept some sort of plea deal just for the monetary penalties combined on all these counts? Because I'm looking at counts 1 through 31. I think each come with a maximum monetary penalty of $250,000. Count 32, same thing. 33, same thing. You think if Trump could just stroke a check that the feds would make this go away?
Yeah, it'll cost them a lot to defend the case, maybe that much. I don't know what their motives are. I mean, and we, I
I
doubt it.
did.
I mean,
They're not going to do that. It's a rhetorical question.
yeah, they've gone thus far. When I was reading about this and listening to stories about it last week, I was like, why in the world would he do this? Why would Trump keep this? And I got a little bit of insight in paragraph 34 of the indictment. That this recounts a meeting with a writer, publisher, and two of his staff members where he said, in responding to criticisms from a senior military official who thought that Trump might order an attack on country A, in the waning days of his administration. You recall all that talk about whether he should be removed from office, whether he was an unstable triggerman about ready to plunge the United States into the Third World War. Well, here's what Trump is saying. He's meeting with the writer, publisher, and two staff members. Hey, look what I found. I found senior military officials' plan of attack. We'll learn who that is apparently at some point. And it's interesting. So he shows him this and he says, let me see. I'll show you an example. This guy said I wanted to attack country A. Well, isn't it amazing? I have a big pile of papers. This thing just came up. Look, this was him. They presented me this. This is off the record, but they presented me this. This was him. This was the Defense Department and him. So I'm guessing that senior military official A, who some general somewhere, had himself engaged in a plan to attack the country that this official thought Trump might attack. The writer says, wow, Trump, we looked at some. This was him. This wasn't done by me. This was him. All sorts of stuff, pages long. Look, staffer, Trump, wait a minute. Let's see here, staffer. Yeah, I would, Trump, I just found, isn't this amazing? This totally wins my case, staffer. Except well, it's highly confidential. Secret. This is secret information. Look at this attack. So, I mean, Trump's doing a little bit of chest thumping there, and he's mindful of the criticism that he was unstable and might launch an attack on someone. So he brings in some folks and he says, hey, they were worried about me launching an attack. Look, the military planner had already drafted a plan. I'm not persuaded that that's anything other than classic Trump knucklehead, because the military probably has a plan to attack just about everything that moves in the world. I think the Pentagon is the world's largest office building, or at least it was at the time it was constructed. And sitting in those offices along miles and miles and miles of corridors are officers responsible for allegedly planning to defend the United States, which means they have to conceive of every conceivable enemy and have a response plan. So the fact that an official had a plan prepared for country A doesn't exonerate Trump of the suspicion that he was unstable on the way out. And it's another example of sort of classic chest thumping on the president's behalf, but it does explain why he would keep some of these documents. I wondered what would be his motive. He's fired, he's out of the office, he leaves. Why would you take confidential papers with you? I guess maybe because you thought you might want to use them for your defense, or perhaps for a biography if you get somebody to ghostwrite it. And so that was a significant tell to me. Of interest to the prosecution, obviously, will be that Trump is not going to be able to say, oh, I took so much stuff out of there, I forgot all about it. I didn't realize I had classified information. This is classic information showing that he did. However, so that's in the minus side for the defense of Donald Trump. That's in the it doesn't look good side. In paragraph 22, though, the government may have opened its door to a defense that it doesn't anticipate. And I'm sure that there will be motions in limine, that is, motions at the threshold of the trial, to prohibit Trump from making the most of this. But they tried to portray Trump as a hypocrite. Paragraph 22 has 5 discrete allegations in it, and it reads, as candidate for president of the United States, Trump made the following public statements, among others, about classified information. On August 18th, 2016, Trump stated, in my administration, I'm going to enforce all laws concerning the protection of classified information. No one will be above the law, end quote. Wonder who he was talking about in that paragraph. On September 6, 2016, Trump stated, "We also need to fight this battle by collecting intelligence and then protecting our classified secrets. We can't have someone in the Oval Office who doesn't understand the meaning of the word confidential or classified," end quote. I wonder who Trump was running against for presidency at that time, and I wonder if he had any certain Democratic candidates for office in mind. September 7th, 2016, Trump. "One of the first things we must do is enforce all classification rules, enforce all laws relating to the handling of classified information," and similarly on September 19th, and similarly on November 3rd. I would be willing to bet that in each of these colloquies, each of these statements that he made, he was referring to Hillary Clinton and the emails from her server that never resulted in a criminal prosecution. And he might be one. He might be want to say at trial, look, folks, why me and why not her? Isn't this the deep state trying to neutralize me prior to my attempt to unseat Joe Biden in 2024. Problem is, there's probably not a trial judge in the United States that'll let his lawyer get away with that. But yet it's in the indictment. You learn quickly enough at criminal trial and in law school that an indictment is not evidence. It's funny. The law works in mysterious ways and usually not to the benefit of people accused of a crime. Whatever Trump says, look at the caption on this thing. United States of America versus Donald Trump. Well, I guess I can't quite see the screen there. United States of America versus Donald Trump and this other guy. So the two parties are USA and Donald Trump, right? Anything that Donald Trump says that tends to show his guilt of the crime charged, anything he says is the admission of a party opponent, and it can be used against him. It's not hearsay. Well, you might say, well, the party that's against him is also a party opponent. And I'm looking at the caption to the indictment, and it says United States of America versus Donald Trump. And the indictment, well, that's a pretty powerful statement of the party opponent. The grand jury endorsed it. They filed it in court, adopting this statement as their own, to charges as their mandate. Why can't a defendant introduce an indictment as a statement of a party opponent in a criminal case? Well, judges will usually kind of wince and stare at you and then mumble something. "We all know indictments aren't evidence." Well, sir, you respond by saying, "Nothing is evidence until you permit it to come into the well of the court." This is no different in form than anything my client, Mr. Trump, has said in any of a number of occasions. And because the government has adopted it and are seeking to deprive this man of its liberty, has filed it in open court, and is acting upon it to my client's detriment in this case, one would suggest the government takes it seriously, and it ought to be admitted as an admission of a party opponent. Denied, counsel. And the appellate courts stand for this. And, just why I just don't understand it. So it's a troubling indictment. I think, in the end, Trump just looks bad. He looks stupid. It's not the case that he just moved out of the White House and took a bunch of junk with him, didn't know what it was. When the government started sniffing around, they started moving boxes so that some of the boxes were kept from the view of reviewing lawyers. He had lawyer 1, lawyer 2, and lawyer 3. We know that one of them was Evan Corcoran, reviewing documents in response to requests from the government and then from subpoenas. Apparently, he used his body man, this fellow named Mr. Natow, to move documents from one location to another, such that when lawyer 1 went looking for them, lawyer 1 couldn't find them. And then what a hothouse of deceit this Mar-a-Lago place must be, because Trump's talking to lawyer 1, and lawyer 1's taking detailed notes about Trump's instructions to him, almost as though he's afraid that Trump is going to be setting him up. And these were the very notes that were subpoenaed to the D.C. And I think this is an interesting question, to the Washington D.C. grand jury, where the Washington D.C. grand jury was permitted to see them by rule of the chief judge of the District of Columbia. That judge reviewed the notes that the lawyer took, Evan Corcoran took, and he required Corcoran, if it was Corcoran, and I believe it was, to turn them over on grounds that they could be evidence of a fraud or a crime. And the crime fraud exception to the attorney-client privilege will penetrate the privilege every time. So a lawyer's notes that the lawyer took about Donald Trump suggesting it would be a good idea to lose some of these documents were taken into evidence by a DC grand jury. And somehow this information went from the DC grand jury to the Miami grand jury, because it was the Miami grand jury that indicted. Now, here's, and I don't know this, and I don't know whether any of you viewers or listeners do. Did people travel after testifying in front of the DC grand jury down to Miami to offer testimony down there? Or did they simply send transcripts from the DC grand jury down to Florida? And is that the same thing as having a Florida grand jury consider the case? I suspect it might be, but if I'm Trump's lawyers, one of the things I'd want to be looking at is something we talked about last week, and that's called the Vicinage Clause, the vicinity clause. The Sixth Amendment says a defendant has a right to be tried in the vicinity and state in which the alleged crime occurred. That trial is I know is different than the grand jury indictment, but I would seek to extend that grand jury proceeding that Vicinage clause to grand jury proceedings, and argue that evidence has to be actually presented in the jurisdiction you're going to be charged at. Because candidly, a lawyer taking notes on his client like that just kind of stinks. And it suggests that a lawyer may or may not have had bad motives. And it gets more interesting. In this, I'm sorry, I kept jump in anytime, cut me off. I'm on this train, but it gets more interesting in the indictment.
You're on the Trump train. Is that what you're on right now?
I'm on the Trump train. Yeah, give me some hair. But it gets more interesting because one of the lawyers was responsible. Lawyer one was responsible for identifying documents, and then they needed a records custodian. That is a person who could say they were aware of where the documents were stored. There was a search for them. These are all the documents that were found. They needed somebody to certify to that. Nobody actually ever did. Lawyer one looked for the documents and then had somebody else, lawyer three, apparently come in and sign something. I'm told that this is all there is. So lawyer three didn't know. Lawyer one may not have known because NATO hid the stuff from him, but lawyer one didn't want to put his name on it because he was too busy taking notes about his conversations with the president to protect himself. And when the end came, and it came time to certify compliance, he asked somebody else who didn't have any idea what she was signing to sign it. Yo, don't ever order dessert at Mar-a-Lago without having a taster. God only knows what they're dishing up at that place. So, it's going to be a fun trial. Well, it's not going to be a fun trial. It's going to be a tedious trial. This is a documents trial. And those of you who aren't trial lawyers or trial junkies, there are several things that make for an uninteresting trial. Videotapes, because you can't cross-examine a videotape. The video gets played for what it is, and you can't really say, you didn't really see that, did you? Because the tape can't answer you. And videos don't have any motives, and the standard for introducing a videotape is whether it's a fair and accurate representation of what it portrays. So often you don't even have to have the person who took the video to authenticate it for purposes of the trial. It can merely be authenticated by saying it fairly accurately portrays what it says it is. A documents trial is almost as bad, because you're going to have document A, document B. There's going to be a chart that connects them all. And so Jack Smith suddenly begins to look like the right lawyer for the job, because if he smiled once in the last 30 years, it didn't get on tape. I mean, I'm looking at Jack Smith as sort of like the Manchurian candidate of prosecutors. He's humorless. He is on some spectrum, and he takes all the air out of the room at hello. So it's Donald's got a problem coming. And the other thing that's unaddressed in the indictment, not even referred to obliquely, is who their source was in the air. So you'll recall that when the National Records Administration, or whatever it was called at the Library of Congress, reached out to Trump to get documents back, they were told that all this stuff was returned, but they got a call from somebody at Mar-a-Lago saying it wasn't returned. Well, who was that? Was it Mr. Nauta? Was it one of the lawyers involved in the case? Was it a member of the household cleaning staff? There was a warrant to go back in to Mar-a-Lago to search for this material. And I suspect in that warrant, we still don't have the name of the rat, the informant, as it were. I wonder who that was. And I don't. And as I read through this thing, I wondered if it was Nauta. Nauta's lifelong military. He was assigned to Trump, but suddenly he's feeling the squeeze of 37 indictments, a 37 count indictment, and looking at years and years behind bars. There's only one way that he can help himself at this point, and that is by truthfully coming forward and offering his testimony about Trump. So it wouldn't surprise me. In fact, I'll go out on a limb. I'll make a prediction. I'm going to say that Nauta has a cooperation agreement with the government, and he will soon be disclosed as the government's star witness in its case against Donald Trump.
Well, I have many questions, and I think a lot of people who have read the indictment, or maybe who haven't bothered. I can't say that I'm, supremely edified by having spent time reading through the indictment. I certainly know what's in it, but the only insight I really have is that this sort of confirms the proposition of, I guess, about selective prosecution or political prosecution. It could be used to confirm, criticism coming from the right that this is election interference by the Biden Department of Justice. But what this reeks of in terms of the substantive allegations, because you've talked a lot about it, right, Norm? You said, how dim-witted a lot of this stuff reads, is sort of Trump as the political outsider. It takes a certain ignorance of this procedural void or vulnerability to fall so blindly into it, I think. Right. And for that reason, it sort of mitigates how, how damaging, or because I go back to, okay, to what end? Okay, we got him, guys. We got him. He didn't declassify this stuff, and he moved it around. And then in so putting his defense together with his legal team, blah, 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 we'll get him on obstruction because it looks like he's moving stuff around and trying to avoid proper scrutiny, whatever. But for what?
No, I hear you. I mean, well, I mean, you say ignorance of the process. There's another possibility. And when it comes to Trump, I think it's a realistic one. And that was arrogance, thinking that he's got to be the smartest guy in the room.
In the Cloud, and the Rumble stream made this point. In the Cloud says, quote, people throw around, quote, narcissistic as a trait of Trump's. And while most don't realize that there's an actual psychological diagnosis of narcissistic personality disorder that exists, the more I look back on things, the more stuff comes out, the more I think Trump might actually have narcissistic personality disorder. Maybe, possibly. I think it takes a very specific type of man to do what he has done over the last 7 years, to ascend to the office that he's ascended. And clearly his ascension has meant a lot to the establishment in a negative way. Right.
Well, it's funny. I'm
wrenching the gears, so to speak. So I think that perhaps anyone that you point to who is on a TV screen shares some combination of the same traits that it takes, whether it's, some sort of sociopathy, whether it's narcissistic personality disorder, whether it's a combination of these various traits that it takes to go all the way and have that type of ambition. But ignorance maybe is a selective word here, because, and I use ignorance to say he successfully navigated his way into the office, but it requires experience to have an elegant exit plan, right? And the political establishment in this country, whether right or left, they know these things. These are institutional knowledge sets that are deployed through the existing status quo in politics. And if they're not deployed, because this is another counterpoint to perhaps what I'm saying, if I'm steel manning a counter to mine, the problem is that the public writ large has no insight into how this stuff is traditionally taken care of. Because as far as I'm concerned, this is a case of first impression for the office of the president in the modern era.
In any era, we've never had a president indicted for crimes.
So to that end, the prosecution has the benefit of this sort of case, the benefit of society's general ignorance as to how these sort of National Archives style United States code provisions are designed to operate, or what harm they're designed to guard against. And even in this case, I'm not sure that it's like the violation of the law in and of itself is the quote unquote harm. Like,
Well, yes and no. Yes and no.
About what Trump would have done, this is going to be the worst. He had an objectively good term as president as far as things go for constituents. If there's some allegation that what he had in his possession was being used for some subversive means, they certainly haven't indicated that in this indictment, have they, Norm?
No, they really haven't. So two comments. First, this business about what kind of psychic state is Donald Trump, and as you were talking about that, what kind of guy is he? There's a wonderful book, for those of you who like, it's Nerd Out Sunday time. For those of you who are looking for something extra to read, it's Harold Lasswell, Lasswell. It's called Psychopathology in Politics. We've talked about it here before. I think it was written in the 1930s. Lasswell was an American political scientist, and obviously, therefore, interested in what kind of people become president or what kind of people become national political figures. And he concluded only the disturbed. He was an early adopter of Freud's psychoanalytic theories, and he concluded that given the aggravation that is incident or that is involved in running for office, the great personal sacrifice, all that you have to put up with, who in their right mind would seek the office? And he concluded, nobody. The people who are serious contenders aren't in their right minds. They have extraordinary needs, and that makes them ready, willing, and able to endure the extraordinary pressures of seeking office. And therefore, don't be surprised. Well, he didn't say this, but I think Mike would. Therefore, don't be surprised when things go bump in the night. As to potential harms, one of the most disturbing. I agree, Mike. There is not a scintilla of evidence that anybody from Iran or Russia or some other foreign government obtained this material, nor is there any evidence that Trump offered it for sale or that he used it to obtain some benefit, whether real or imagined, from a third party. He seemed to hold on to it as souvenirs or almost as narcissistic defenses. General A is, this general guy is going to accuse me of being unhinged. Look at his plan of attack, that kind of thing. That's why he was showing it around. But here's one of the things that surprised me. When the documents were getting moved around, they were moved at one point from a room onto a stage at Mar-a-Lago. And so the indictment goes on to read that during a 18-month period, there were 150 public events at Mar-a-Lago. So you get the idea that dancers were perhaps within eyesight or arm's length of these documents and just didn't know. But the more telling one, and I wonder whether this is what broke the case and what brought it to the attention of federal investigators. There were documents in some box in a hallway or in a room somewhere, and the box fell over, spilling documents onto the floor. And somebody came into the room and saw something with a top secret stamp on it. That is an extraordinary lack of care. It doesn't show harm. These are status offenses, and the claim is he had government property. That's bad enough, but not too bad, especially for a president. The serious claim is that when they started asking questions, he obstructed justice, and he, for corrupt reasons, decided to obscure an investigation or to defy an investigation. That's going to be hard for him. That's going to be hard for him with the jury, I think.
It certainly is, but I don't know that they're even in a. This whole thing bothers me because of the lack of precedent, because this has not been deployed against a former president in the history of the United States. And yes, okay, the story in and of itself, the anecdote where something spills over, there's the top secret indication on a document, who may have seen it, to what end, blah, blah, blah. Okay, I understand. Are we also going to say that this has not happened in any other former president's life in any form or fashion that's substantially similar to that? Earlier this year, we got a window into the fact that the current president of the United States has a bunch of documents sitting in a garage.
Yeah, no, I got it.
Right. And that's what strikes me about this entire thing. I don't expect that, there's stuff in the indictment that talks about the way that Trump was communicating with an interviewer. I think he was actually talking to an agent, perhaps for a book deal. And, on paper, it's tough to understand the inflection and the context of some of the stuff that they've included there, which is a strategic decision on their part. And I think we both understand why they would want to do that. But even in the just looking at line by line and taking it for what it is, it's it's not outside of his character. I try to think of hearing Trump say these things like, "Hey, don't get too close. This is technically secret. Don't look too close at this document I have over here." It seemed more like a negotiating tactic, a way to compel even further intrigue with what he was talking about, right? As in traditional Trump fashion, to be you know the elite negotiator that he has.
Or in the alternative, the bobblehead doll saying, "Look what I got," but you can't see it, but I can tell you,
Right, but
Um,
what is the difference, right? I think that I've had more experience in my practice, dealing with those who negotiate extremely well through perceived ignorance. And Trump, I think, does that on a level that is perhaps unappreciated because most people haven't seen that work in practice. But it works really, really well, Norm. But the DOJ is taking full advantage of the fact that there is just tabula rasa on this as a legal precedent, right?
No, that's really true. And I mean, I was interested, and I haven't taken the time yet to read the various executive acts that create the classification structure for documents. But we learn, there's top secret, there's confidential, there's, don't show it to foreigners kind of stuff. And then there are these,
Exceptions, need to
ex-
know and waivers and stuff like that. Yeah.
but how many million upon million, if not billions at this point, of documents have been given the secret stamp? And I mean, I can't help but be struck with the irony that the very week Trump was indicted, we were putting to bed fires relating to Christopher Wray's defiance of a congressional subpoena with respect to the identity or disclosing the identity or information from the source of a report that Joe Biden took a $500,000 bribe while vice president of the United States, or a $5 million bribe. Excuse me, I got the number wrong. If in the relative scale of things, it's always wrong to take a bribe. And it's always important to know if a public official has. I can't say that it's always wrong for a public official to have a document when he leaves office, and I can't say that it's right to prosecute when he does. However, as to Donald Trump, he brought this trouble on himself. And, I remind everybody of the Martha Stewart problem. Martha Stewart was accused of insider trading, and they were never, the feds, able to get a conviction on her as to that. What they got her on was the procedural stuff. She lied to the feds. She played cute. She thought she was bigger than the law, and she tried to hide. I think that this might be Donald Trump's Achilles heel. That he thought he was bigger than it all. He thought they'd never do this to a president. He thought he could call on his supporters, and that the Justice Department would stand down. Now we have the very real prospect of a criminal trial on these charges during an election season, with the promise, according to Trump, that he would serve even if convicted, so long as he were elected. And you want to get down to sort of brass tacks on law and legitimacy, our core concept: legitimacy, respect for public institutions. How many tens of millions of voters are going to vote for Donald Trump in spite, or not of this, in spite of this, in spite of this indictment? And did the Justice Department do more harm than good to the nation by bringing it? Jack Spratt, who, that is Jack Smith, the humorless one, Inspector Javert of the Justice Department. "No one is above the law," he intoned. Well, that's true, but that doesn't mean that the law has a carte blanche right to be an ass. And it used to be that the Justice Department had a public integrity unit that made decisions about whether prosecutions were in the public interest. So at this point, what's the Biden administration saying?
Well, isn't that sort of the essence of my question about to what end? Right?
Yeah.
Is this this is an indictment because of a technical violation of United States code or allegations thereof? But in I guess from where I'm sitting, the public interest would be served if and only if there were some sort of external occurrence that damages the United States in its foreign diplomacy, domestic interventions, these sorts of things. And I'm not saying that we need a certain harm befall us, but I certainly would expect that if there was an office of, public integrity, and they were looking at the relative balancing test that I'm sure that they would want to go through over the decision not to pursue an indictment on this stuff versus the decision to, one would want to look at, well, what harm are we mitigating against other than the violation of the substantive rules themselves?
Well, but let's focus on a couple of these charges. So, some of the charges are, I'm going to nerd out here and use the statute numbers. 18 United States Code 1512.
And Norm,
Uh,
just to ask before you go on, do we know, because I didn't look this up, so I'm sorry for telling on myself, but what are the statutes of limitations on these federal charges? Do we know that?
I don't. They're typically 5 years, though. So, I mean, there's not going to be a statute of limitations issue. Misdemeanor is usually a year. The standard run-of-the-mill criminal charge is usually 5 years. I didn't look them up either, but I don't think there's going to be any issue. That would be an obvious one for these guys not to blow. But look,
and I'm only asking because I'm wondering if this could have waited.
Oh yeah, well, it could have. Yeah, no question about that.
That's
the timing,
point, right?
Timing is everything. A congressional oversight, of course. Well, let's talk about that in a minute. But you're talking about substantive harm. So a number of the allegations arise under 18 United States Code 1512. These are allegations that pertain to corruptly obstructing an official proceeding, and they were enacted, I think, incident to Enron. The statute was acted in incident to Enron, and the public or the corruption cases that were brought then. And the fear was that as Congress and investigators began to look around, people destroyed documents, and so the Congress passed a law that basically said if you know there's an official proceeding and you obstruct it with a corrupt intent, you're going to face major prosecution. Now, of interest, the 1512 proceedings were used against the Proud Boys. And they were also used against the Oath Keepers in their conspiracy prosecutions. And the claim, and it's something that outraged us at the trial level, because our view was we don't. We weren't trying to obstruct an official proceeding. This wasn't trying to tamper with a witness or hide a document. This was a protest gone bad. And to act corruptly is usually to act for some venal purpose. These individuals had gone to the White House that day to stop the steal. And there's nothing corrupt about that. That's the essence of patriotism, especially when your president is standing a mile or so from the congressional building, saying, if you don't fight for a country, you won't have a country anymore. Now, mind you, what I'm not saying that anyone entering the Capitol grounds on January 6th was justified because of Trump's speech. I'm simply saying that if they were reacting in response to the president, the commander-in-chief's speech, they weren't by definition doing so with a corrupt purpose. Now, with respect to Trump, when he becomes aware of a request for these documents because there's an official proceeding, a grand jury investigation going on, and he hides them. The question is that the sort of harm that the Enron Congress intended to prevent? And no, I would argue it is. You're looking for documents. With respect to,
we're not going to even see them. There's no allegation here that documents. Well, okay, I want to back up again because I like going back to our streams, Norm, because
by the way, wait, I got to ask Pat Clifton, the other angry dog. Hi, Mike. Tell us about the other angry dog, Mike. Who's the other angry dog?
Well, that's the separated at birth twin of the original angry dog, but we'll say the other OAD is the acronym for other angry dog. But hey, Pat.
All right, I wondered what that was. Hey, welcome, Pat. Good to see you. So what were you going to say, Mike? You wanted to go to the stream.
Streaming this theme about the confidential human sources in previous streams, and I don't want to lose sight of that because this sort of document case feels and looks a lot like the issue that you and your co-defense counsel in the Proud Boys case continue to run into, which is there are these allegations of these certain things, except there's never any disclosure of the actual things alleged. They're just supposed to be taken as true and as the gospel for purposes of rendering a judgment, whether it's jury or judge, right? And that seems to be the case here. Does
It's
that
a
make
great issue. No, it's a great issue. Let's take, I mean, and you raised this the other day, and I kind of tap danced around it because I didn't know enough, but now we know plenty. If you look at the indictment, and, indictments are like all legal documents. If they're well crafted, you have numbered paragraphs so that when you try to talk about them in court or on a podcast or anywhere else, you can refer others quickly to what you're looking at. So take a look at page 28. And, you're asking yourself, ladies and gentlemen, well, what are these documents? What's disclosed? And Mike is asking, if they didn't fall into the wrong hands, what's the harm? Now, Mike and I have a difference of opinion on this. I think Mike's position is, in the absence of a discernible harm from the documents not falling into the hands of a third party, the basis for the prosecution is less robust. I would take the position that when you're aware that there's an official proceeding and you affirmatively hide things from the investigators, that's a serious offense, especially if you're a former public official. But let's bracket that for the moment. So here's what we know about document number one in count one. That there was a document labeled top secret, no foreign. In other words, wouldn't be given to a foreign national. And it was so sensitive that there were special handling rules for it. So you learn in the indictment that some documents are so radioactive, the truths they reveal so stunning, they can only be reviewed in a SCIF, a secure confidential something or other. I don't remember what the IF stands for. So this was a document dated May 3rd, 2018, concerning a White House intelligence briefing related to various foreign countries. That's all we know about it right now. And there's a description of other documents that go in a similar vein. So here's a question for trial practitioners. The government at a criminal trial has the burden of proving each and every element of the offense it charges. And so one element of the offense in this case is the handling or the mishandling of confidential documents, of top secret, documents that Trump was not authorized to have. How are they going to prove that the document's top secret? Do they just get to submit a list, or do they get to show the jury that document, or are they required to show the jury that document? And I'm of two minds on that. If I were defense counsel, I'd take the position the government's got to show us the document. And the reason I would take that position is because the government wouldn't. And then you'd be able to claim that in the absence of that evidence, they can't meet that element, and the count must therefore be dismissed for insufficient evidence. But I'm wondering, Mike, wouldn't it be enough for them to produce an FBI agent saying, I reviewed the contents of this envelope that's under seal. It's in count one, and it's a memorandum, a document dated May 3rd, 2008, concerning a White House intelligence briefing related to various foreign countries. Defense lawyer, what foreign countries? Objection. But judge, how are we going to know it's true? A foreign country, its identity is not necessary. What's necessary is, was that document labeled? The agent would be asked. Yes. What was the labeling on the document? Top secret, no foreign special handling. So at that point, the defense lawyer will push back and say, well, that's hearsay. The best evidence of the document is the document itself. A trial judge making decisions about evidence gets to use their discretion, meaning they get to decide how to apply the rule. So I can see a range of decisions here from differing judges. I think that most judges would probably say we will redact or just, white out from public view the actual identity of the foreign countries and the information, but we'll leave the marking on it because
right?
It's the
Okay.
marking that makes the document prohibited. And I think the case proceeds on that basis.
Yes, of course. And I think that I don't think
Well, I'm sorry to be so tedious about it, but this is
tedious
law.
at all. I want to make sure that we don't get dragged all the way down into this, because it sort of leads to just sort of a dead end on my end. Because I can respect that in a perfectly legitimate system, or at least one that still retains the perception of legitimacy and not some sort of political bias or institutional bureaucracy kind of picking and choosing winners and losers, right? That standard would abide. That nearly 99% of the people that tune in for our streams, that go to the voting booth, that generally engage with the civic process, would say, yes, in the interest of national security, domestic defense, our interests abroad, that would be sufficient for that to be legitimate evidence in a criminal prosecution. of this type and variety. But what we know is that context builds a completely different picture, Norm. And so from where I am sitting, this is the same president who has been exonerated multiple times during his presidency. And then the Durham report was released, what, a month ago, 6 weeks ago? And it talks about the Steele dossier and all the litany of issues, and then the 50 intelligence, the intelligence signatures saying that the Biden laptop had all the traditional markings of Russian disinformation. These are the offices of the same people involved in this, and saying to the judge and to the court and to the public writ large, Trump's 80 million voters that he has that are going to vote for him again in 2024 from wherever he's having to run his campaign. They're saying to them, "Oh no, this is in our best interest as national defense. You must just accept the fact that we can't disclose any more information about this than we've disclosed here." That's ridiculous. On its face, that is ridiculous because the context dictates otherwise. And that's why I talk mostly about this sort of like process-related crime, that Trump walked into this not having an elegant exit plan transactionally, from a transactional perspective.
Do you think Martha Stewart should have gone to prison for lying to the feds in the investigation of her insider trading? Yes
I'm
or
the
no?
wrong guy to ask about that, because I
know, but you're the guy I'm asking.
I don't know. I don't know.
I mean, so the fact that you can't. What's that?
I know that she did. Right.
Well, my understanding is
insider trading. Wasn't there something related to insider trading with Martha Stewart? And didn't she?
Yes.
Okay.
She was being investigated about that, but she was acquitted of that charge, but convicted of lying to Congress, or lying, excuse me, to the FBI. And it's a federal offense to lie to a federal official, although it's not a federal offense or even unethical for a federal official to lie to a defendant or an investigated person. They get to lie to you as part of their investigative practices. You don't get to lie to them in self-defense. If it's a crime to obstruct justice, then that is whether you prove harm or not, it's an offense against the administration of justice. And Mike, you and I are both familiar with this from our legal practices. We've sworn we've sworn to codes of professional responsibility. We could lose our license for conduct that obstructs justice, hiding a document, lying about it. Should ordinary citizens be held to the same standard when Congress or the feds come knocking?
I don't think that I'm making. I don't think I'm making I don't think I'm taking the position that they should not. But I am taking.
If they shouldn't, then why not Trump?
I'm not saying that he shouldn't either, but I am saying that in this context, if it's going to be, there's not a judge in the country that would listen to that. I mean, I assume that Trump's legal defense is going to be barred from entering any evidence related to the Steele dossier or the Durham report or any of these other things, right? I mean, you would expect that the judge would not allow them to bring in these sort of collateral stories that would actually build a case for why Trump would be mistrusting of, right? Like, because ultimately you're building some reason to say this wasn't obstruction. This was him trying to avoid yet another fishing expedition, right?
So Trump, yeah, possibly. And you're right. I don't think a trial judge is going to permit it. So where the case, I mean, I think he's lucky the case will be tried in Miami, where there's a large Republican base. I think if he were tried in DC, the results would be a foregone conclusion. It's looking to me like Justin Carter is liking where you're going, Mike. He says, "Preach, Mike, preach."
I think this is just my intuition on this mostly. I mean, having read this, and I'll read it again, and we'll continue talking about these things. And I'm aware that, I think the one thing that I don't necessarily like, but perhaps I have to stop being so wishy-washy about it, is Justin's prior comment asking a couple of saying, what harm was done. I don't think that that's the proper perspective on the analysis, right? I don't think that that's an enduring way to think about these things. What harm was done? Who got hurt? I don't know that that's where we start, right?
I'm laughing because I'm reading Bathtub Liquor's comments on Rumble. Objection. You can't say Hillary Clinton now. Hillary Clinton, Norm. Counsel approached the bench. It suggests to me that she was a watcher of the Alex Jones trial, because we tried to raise Hillary Clinton's name and Jones's motive for making certain comments, and the judge wouldn't tolerate it. She said it will distract the jury, and we're not going to hear it. I don't want to hear Hillary Clinton's name mentioned again. I was threatened to be held in contempt. She had her reasons. We'll see what the appellate court has to say about it. So Suze, that's a new listener. S-U-S
No,
S-U-Z.
Suze Day is she follows us on Twitter, or I'm saying Suze and assuming that it's a she. It could be a he, but Suze Day follows us on Twitter, shares every single stream, likes your and my tweets, and I don't think that Suze Day is able to get to our live streams at 8 a.m. for whatever constraints his or her day to day, but was definitely excited to be. Yep, for Suzanne. Okay, well, what's up, Suzanne? And we appreciate you. But yeah, she's in here, and I think she's just happy to actually be in here.
There is nothing, absolutely nothing Trump can do or say. I suppose that's true. I'm simply pointing out the differences, blah, blah, blah. That's true. And In the Cloud points out that the judge in the Jones case was not a Norm fan. You think?
Girl,
that's right.
Girl quotes from I think the book that you've been hawking for a little while now, Norm, but Show Me the Man and I'll Find You the Crime. And that's sort of where I was going. I think that perhaps I need to read the book, three felonies a day or 3 crimes a day. What's the title?
Yeah, 3 felonies a day. Harvey Silver Glate. I think it's Glate. He was I think a columnist for the Boston Phoenix. The book's a little old now, 20, 25 years old, I think, at this point. But I'm sure the point is even more valid than usual, or it was then. And that is, there are so many federal felonies that prosecutors get to pick and choose when to charge them. And in terms of this case, United States of America versus Donald Trump, I think tomorrow we'll probably pivot into a more political discussion of the indictment. If you're frustrated, folks, about why we haven't addressed the larger context of it, we thought today we'd focus on the mechanics of the indictment and the mechanics of the allegations, so that you had a little bit better sense of what it is that the government's going to be proving, and what some of the obstacles to that proof are, and how easy some of it will be to prove. Obviously, Trump has a right to remain. Here's a thought: Can Donald Trump, Mike, don't can Donald Trump exercise the right to remain silent?
Absolutely not.
He has a constitutional right to remain silent, and the government cannot compel him to testify, and they cannot use his silence against him. But he has a right to testify if he so chooses, but only when the court permits him to speak. And watching Donald Trump sit through a criminal trial would I think I would need a tranquilizer, and I think maybe even more than Donald, because I just can't imagine him submitting to the orderly process of a courtroom. But the fact, your point is well taken, Mike. I mean, why this? Why now? And what's the precedent? We've got Bill Clinton stuff in his sock drawer, Hillary his server, Joe stuff in his car in his garage. We've got Hunter with his crap on a laptop that intelligence officials lied about. We've got the CIA stonewalling Congress about confidential human sources, and the director himself being threatened with contempt. And now we have this. This is on the cusp of the 2024 election. It's hard not to think that politics had something to do with this decision. And as humorless as Inspector Javert, Jack Smith, may be, he's probably the right guy for the job, because I doubt he'll ever crack a smile in this case. He will always be the man for justice. No one is above the law. And the Justice Department now swears that every person who steps into ongoing traffic in defiance of a red light is going to somehow affect interstate commerce. And we intend to bring the full weight of the law on every act and omission that we can discern, because no American is above the law. Whether you're a homeless waif wandering the streets in search of your next meal, or the former president of the United States, I'm Jack Smith, and I'm going to fuck you up. I mean, is that what this country's come to? Jack, get a life, pal.
I'm Jack Smith, and take it like a man.
Yeah, because I'm bringing it. Well, I don't know.
Well, look, I think that we should probably end it there, Norm.
Right.
We've got plenty that's transpired over the weekend, but I think that the arraignment is scheduled for Tuesday. Am I right about that? It's either Tuesday or Thursday of this week.
Well, I thought Tuesday or Wednesday. Let's put it this way. It's going to be this week, Yeah.
We'll definitely be covering that. And I also think that there will be more to come. I'm, anxious to see how Trump goes on the offensive via Truth Social. He's also been posting more to Instagram through his verified account lately. Definitely had the video of him, spliced together with Biden falling here lately. So he's still very much in campaign mode. That's not going to change. I think that this case may backfire on the DOJ a little bit, because to the point that you made earlier, I don't know that anything that the establishment, the Department of Justice, at least the Biden Department of Justice, does at this point is going to do anything except further entrench the Trump base and likely convert voters that are in the middle on the Republican side, right, at least with respect to the primaries, further into the Trump camp. Vivek Ramaswamy has done the media circuit this weekend. He has been advocating for the media to return to the journalistic integrity that it historically had, and to be asking the more important questions about this. He has asserted that the establishment media would not permit a DOJ to treat a Democrat candidate for president the way that they are treating Donald Trump, and would certainly not be as incurious as they've been. So I'm loving where Vivek is going. I think that he is going to continue to gain ground. I think DeSantis is losing steam, and he has not treated this situation in the way that you would expect somebody serious about achieving the highest office in the land.
Let's face it, DeSantis is like Jack Smith. He's just a humorless drone.
Yep.
I mean, one of the things I like about Trump is his irreverence and his insouciance. I mean, it's like, oh yeah, you think you're going to get that? Come get it. I mean, I'm not sure I'd want to have dinner with the guy, but I posted a poll on Twitter over the weekend. Okay, Trump's been indicted. You have to choose between Biden and Trump. Now, admittedly, my Twitter feed, it's a silo. I mean, if you're out there burning bras for Oprah, I'm probably blocking you because I can't stand the smell of crusty, of smoldering latex. But it's like 90-something% of people are going to vote for Trump out of a couple thousand votes cast.
I was going to say, I mean, you've got 1,880 votes. Let's get this up on the screen just so everybody can see. You've got 1,880 votes, and the question is there. Okay, Trump has been indicted by the feds. It's Trump versus Biden in 24. Your vote: Biden 3.2%, Trump 92.1%, and I'll pass 4.6%. But look, we've got 1,880 votes, and there's still 6 days left. So if you're on Twitter, follow @PattisNorm, follow @PattisPodcast, and indulge this and share it, and continue to get it into circles so that we can disabuse Norm of thinking that this is just a silo. Because I actually think, Norm, you don't really have as much of a silo as you perhaps think you do.
Nobody pays any attention, right? It's not that they're like-minded people. No, but listen, here's the deal. How bad are things in this country right now, Mike? How bad are they?
I don't know. How bad are they, Norm?
They're so bad. The Unabomber committed suicide over the weekend. I don't know if you saw it. I got a text from somebody, and he was like in North Carolina, and I'm like, how could he be in North Carolina? I thought he was at Florence at the Supermax, where they keep all the badasses. The only thing that I know in Florida is the Butner Medical Facility. Well, that's where he was. He'd been transferred there earlier in the year for unknown reasons. He's about 25 years into his 4 consecutive life terms, and he died. There's a suggestion that it was suicide. I mean, he was 81 years old. People are already saying, oh, there's going to be an inquiry. It's sort of like Jeff Epstein. No, it's not. I mean, what did you expect the Unabomber to do? Start engage in the Jane Fonda workout so that he could pass the age of 90 inside of custody. The Unabomber, Ted Kaczynski, wrote some interesting works. He was largely prophetic. He talked about the rise of a technological society and a surveillance society, a society in which, in the name of the public good, our lives were made uniform and we were required to march in lockstep to someone else's version of the good life. Sound familiar? I'm not suggesting the Unabomber was right to bomb people. He killed 3 people. I think 16 others were injured. It was a campaign of terror, but he was a lonely prophet, and now he's dead. Take a look at the Unabomber's works, one or two of you, and give us a call at what you think about them. I think he had insight that the world couldn't bear, and I think the world broke him. We'll probably be the only podcast in the United States noting his death with a sense of loss.
Norm, I always like doing these little Sunday specials, and I think the attendance here would confirm my preferences. We should do more as we have the opportunity, but I'm looking forward to this week. We've been on quite a tear lately, and we'll be back tomorrow morning at 8 a.m. bright and early. I think Justin Carter said he'll be on the West Coast, so he'll be up at 5 a.m. He's still
Justin, whoa, baby,
beat Luttrell to the box, Anyway, you can find us on Apple Podcasts, Spotify, Google Play, Overcast. If you didn't listen live, if you're there, please give us a 5-star rating. And if you don't want to give us a 5-star rating, just don't bother voting. But you can also find us on Rumble Live, YouTube Live, Twitter Live every day starting at 8 a.m. Eastern Time. And, Norm, if you have anything to tell these people, I think the only thing that I'd like to just remind them of is that we have a goal of hitting 2,000 followers on the podcast Twitter. So please follow us. Hit the
follow us on Law and Legitimacy. Just click it on Law and Legitimacy and then hit the follow button. You don't have to pay attention to anything you say. But if we get to 2,000, I guess we get some special perks with Twitter, and that makes it easier for us to keep alive when the censor comes looking for us.
Absolutely. All right, Norm. Well, I'm going to give you the rest of your Sunday back. Thank you, everybody, for tuning in. And we'll take a little bit more of a political perspective tomorrow morning on this topic and others.
Ciao.
See you, Norm.